Hey, good afternoon, everyone. Thank you for joining us for our webinar today. So without further ado, by way of introduction, my name is Carly Forrest and I am a partner and solicitor advocate within the insurance and risk team here at Brodie's. Joining me virtually today are my colleagues Kate Donachie, Managing Associate, and Gemma Nicholson, Senior Associate, both of whom also practice in the insurance and risk team. Now, the webinar is titled Predicting the Unpredictable, the reason being that there is no precedent for the current pandemic, which we are all facing at a global level. This is the first in what will be a series of topics related to COVID claims, and if there are any particular topics that you would like us to cover, then please let us know, with the caveat that domestic claims are not ones that I want to become involved in. So everyone who's been given a bad haircut at home, they do say the difference between a good and a bad haircut is 2 weeks. So hopefully by the end of lockdown, we should all be back to normal. So for the purposes of today's talk, we have used our industry knowledge and experience to predict what the future may hold in terms of the sorts of claims we anticipate being pursued as a result of COVID-19. But as everyone knows, this is an evolving process, and we do appreciate there will be particular issues within each industry sector. And we would encourage feedback from everyone listening today to allow us to tailor future talks and the commentary and advice that we issue to address the real issues you're coming across in practice as a result of the pandemic. Now, for today's purposes, once we have looked at the main areas that claims are likely to flow from, we're going to go on to look at the risk assessment measures that businesses ought to be considering to minimise the risk of claims occurrence. Kate will also be talking about what is an acceptable level of risk. We're all hearing daily media reports of employees and unions lamenting the fact that it's not completely safe to return to work. But what does that mean? What are the legal duties on employers? Completely safe is not one of them. But where is the line between what is an acceptable level of risk in law and what is not? Gemma will then come on to talk about defensibility strategies for claims that do arise, even when suitable measures have been adopted. And I will finish by talking a bit about causation and the claims we anticipate will arise as a result of COVID. So we have lots to cover over the next 45 minutes or so. So just out of interest, it's worth considering that COVID-19 was listed as a notifiable disease by the UK government on the 5th of March 2020 and slightly earlier in Scotland on the 22nd of February. Now, that means that GPs by law have to report the diagnosis of such diseases to either Public Health England or the relevant Scottish Health Board. Now, in the same day as Boris Johnson described the pandemic as the worst public health crisis for a generation, companies called Coronavirus Claims Limited and Coronavirus Compensation Limited were registered with Companies House. Other companies set up around the same time include Coronavirus Payouts Limited and Coronavirus Legal Solutions Limited. And I ask you whether that's coincidence. I'm not sure it is. Press reporting, whether you consider it to be responsible or not, has hailed COVID-19 as the new PPI. And really that's why it's key to know now what those claims might look like and how to protect you and your customers, your clients and your policyholders. In terms of fraud, it's worth mentioning that we need to be alive to the prospect of an increase in fraudulent claims, bearing in mind that when a recession hits, fraud numbers tend to increase. We see that from the 2008 recession. That led to significant increases in the number of people who take the view that insurance fraud is a victimless crime. We could see an increase in, for example, ghost brokers, online scams from fraudsters. There's been lots of press reporting about that, who are seeking to capitalise on people's anxieties arising from the pandemic, claiming to offer insurance for COVID-related risks, or in a motor context with fraudsters induced accidents targeting commercial vehicles who are likely to be insured, or in the context of EL or PL claims where we see exaggeration sneaking in. We need to be alive to the potential for fraud and this is something which we'll cover further as part of our programme on COVID claims going forward. I wanted at this stage to pause to consider the impact of COVID on insurers generally. The indication from the ABI of the impact of COVID across the industry is that insurers in the UK expect to pay at least 1.7 billion in claims as a result of COVID-19, and that includes over 900 million to businesses and 275 million to people claiming on travel insurance. Lloyd's of London has also said it expects the event globally to have more impact on the financial position of insurers than the 9/11 terrorist attacks or the 2005 hurricanes, with the global and systemic nature of this crisis challenging the industry in a way that has never seen before. So what are the potential claims we expect to see over the coming weeks, months and years? Well, there's really two categories which I've split them into. So we've got the direct or first party claims and indirect or third party claims. So firstly, dealing with direct claims, the vast bulk of the claims insurers have received from policyholders are in relation to business interruption cover. There's been a lot of media coverage about BI claims, and we know of the well-publicised group action by 500 or so smaller businesses against Hiscox as a result of the refusal to pay out on BI claims for those businesses. I read this week there have been reports of Hiscox offering three-figure sums to certain small businesses, admitting that it should have been clearer in the explanation of when its policy would provide cover for lost earnings resulting from the pandemic. Now, ultimately, whether or not a BI claim is likely to be paid will depend entirely on the policy wording. Most policies with basic BI cover will not pay out in relation to the pandemic. However, some policies with extensions covering infectious disease, for example, will be entitled to claim on their policy. And just yesterday, the FCA announced that 8 insurers are going to be involved in a test case, which will run in the High Court of England. And the background to this is that the FCA have looked at multiple policies and multiple insurers across the market to identify the wordings used most widely. And the aim of that court action is to obtain direction from the court and to achieve clarity for all concerned in an unprecedented situation, so for policyholders and insurers alike. The FCA has come out to say that most SME insurance policies are focused on property damage, so in the majority of cases insurers are not obliged to pay out in relation to the pandemic. But the test case is focused on the remainder of policies that could be argued to include cover. The estimated timeline for that is a substantive hearing in July, but obviously that is subject to direction from the court. We'll update on that as and when there is anything further to report, but in the meantime, I would expect there to be ongoing dialogue between insurers, brokers and policyholders about these issues. Then if we turn to look at the indirect claims, so those being made by third parties, so such as EL or PL claims, one source has already reported an increase of more than double the number of casualty claims it's recorded within the last couple of weeks relating to COVID. So this really is something we all need to be alive to. In terms of the first area where we see we are likely to see a potential influx of claims is infection. So those who have contracted the virus, either in an EL or PL setting, and such claims are likely to be based on a breach of duty, such as inadequate measures being put in place to allow social distancing, or a lack of PPE, or a lack of hand washing or welfare facilities, or suitably robust cleaning practices being put in place. Now, I'm going to come on to talk about causation in the context of those claims later, but we anticipate that that type of claim will be advanced across all sectors, although the most obvious ones will be those, the frontline sectors, which have been struggling to obtain adequate PPE, so particularly the healthcare sector and particularly care homes. With headlines such as those which you see on the slide, it's not difficult to see that this sector is arguably an easy target for those seeking to pursue such claims. Although if we look at some statistics, just from last month, the Office for National Statistics published some data on COVID-19 related deaths by occupational groups. And the analysis showed that there had been a significantly higher death rate among men and women working in social care, so that included care workers and home carers, than amongst healthcare workers, so the doctors and nurses who are working on the front line. There was 131 deaths recorded in the first category and 106 in the latter. And actually, the statistics found that healthcare workers were not found to have a higher rate of COVID-19 related death than those of the same age and sex in the general population. So I thought that was quite interesting, although it's one study, so we have to take it in the context it was designed for. I think the healthcare sector is also at risk of other claims which have arisen as a result of COVID. So claims such as, the result of a misdiagnosis, for example, of being unable to attend your GP for treatment or for referral onwards for specialist treatment. And the most severe outcome for those who have contracted COVID is, of course, death, tragically. And as we all know, damages for fatal claims in Scotland are far higher than those south of the border. So even if the number of cases in which causation can be established are low, if the outcome is at the most severe end of the scale, the potential payouts in terms of damages could be significant. And then moving on to mental health, and this is really the main area where we suspect we're likely to see claims volumes, and there's a number of factors to consider here. Firstly, those employees who claim they have suffered a psychological injury as a result of being, in their eyes, forced back to work when it was unsafe to do so. And as I said, Kate's going to come on to talk about the context of safe shortly. Secondly, those employees who have been under increased pressure in terms of workload because of the pandemic. So if we take, for example, the banking sector and a call centre with 300 customers who all of a sudden all need immediate help in terms of with their finances, with business loans, with extensions for payments, does the organisation have the additional resources, the additional capability and the protection measures in place? You add to the increased workload the likely staff shortages due to illness and or people who have to self-isolate, and where the remaining employees are subjected to increased workloads in very challenging circumstances. Where employees are having to cover for others as a result of absences, employers should take care to avoid the situation where employees are covering for others in another role and therefore they're not trained or not as familiar with using a piece of equipment or a piece of machinery, which can also lead to accidents happening. And what about home workers? Well, the advice remains that those who can work from home should be doing just that. The general consensus is that most industries have adapted well, and given the technology that's available, most office-based workers are indeed able to work from home. But those working from home should be afforded the same level of care as those who cannot. So a lack of communication can lead to employees feeling isolated and vulnerable. From all of the desk photos, which we've all seen posted on social media, many people are having to work from the kitchen or the dining room table, their bedroom. It's not ideal, and at the same time juggling family commitments such as childcare, homeschooling, caring for elderly relatives, and all of these factors could lead to employees developing stress, anxiety or other psychological disorders. And out with the mental health context, and again bearing in mind the office setup, there is a risk that if employees are not provided with adequate equipment, we could see an increase in the number of musculoskeletal claims, damage to eyesight, recurrence of headaches as a result of poor display screen equipment. And my final point is in relation to vicarious liability, because as everyone listening today will know, employers are vicariously liable for the negligence of their employees for negligent acts carried out in the course of their employment. Now, an example of this in the COVID context might be an employee who fails to wear PPE provided, is a carrier of the virus, whether knowingly or not, and infects a colleague or an employee who causes injury to a colleague or a member of the public. So you have the risk of transmission from someone who doesn't wear the PPE, or you have someone who hasn't been trained on something, they go out, they injure a member of the public or a colleague, and the employer is vicariously liable in that scenario. The risk is also that if employees are overworked or fatigued due to staff shortages and increased workloads, and again, if they go out and injure someone, a colleague or someone external to the business, the employers are responsible for that. Now, having delivered all of the bad news, I'm sorry about that, about what the future might look like in terms of the claims we may see, I'll pass you on to Kate for hopefully a more uplifting talk on what measures ought to be considered to seek to minimise the potential for such claims to be made.
I'm not sure I would go as far as say it's uplifting, but we're going to look now at assessing the risk. Safe, dangerous, at risk, COVID secure, all terms which, understandably, we're hearing a lot at the moment. But what is an employer obliged to do to protect its workers? Clearly, getting that right now will reduce the likelihood of getting claims in the first place, but it should also increase the ability to defend them if they do occur. But there is so much guidance and it is changing so often that it can feel difficult to navigate what is required. Employers who are looking to bring back staff and restart operations are facing two challenges at the moment. One, assessing and managing the way in which the existing practices and control measures have been impacted by the outbreak, and two, assessing and measuring the new risks which have been introduced by the outbreak. Some more phrases we've been hearing a lot: unprecedented, novel, extraordinary. But in fact, the duty on employers and the process they must follow have not changed, and they're anything but novel. The overarching duty on employers is found in the Health and Safety at Work Act 1974, and it imposes a duty on every employer to ensure, so far as is reasonably practicable, the health, safety and welfare at work of its employees and others affected. And Regulation 3 of the Management of Health and Safety at Work Regulations 1999 requires every employer to make a suitable and sufficient assessment of the risks to the health and safety of its employees to which they're exposed when they're at work, and the risks to the health and safety of people not employed arising out of or in connection with the undertaking. And that assessment is to allow the employer to take the necessary measures to comply with the duties under the Health and Safety at Work Act. That all remains the case now, and this then is a starting point, the risk assessment. But remember, when you're looking at risk assessments about coming back to work after COVID-19, the risk assessment must be an overarching approach to the whole operation, not just the measures which have been introduced because of COVID-19, because lots of things have changed and you're not going to know where the impact of that will be felt. So this process can only be done if the person or the people who are carrying it out know and understand everything that's done by the operation and are in a position to assess and identify the hazards. And COVID-19 increases the reach of what will need to be considered in this process. An example of that is the risk to workers when they're travelling to work. It's not something that employers usually need to consider or manage, but it is now. Always essential, but even more important here is communication with employees, unions and other worker representatives. The Scottish Government underlines this requirement in its guidance in several places. A two-way communication with workers from the outset should assist engagement and should serve two main purposes: to reassure workers that their safety is being protected and to increase the likelihood of compliance. And they're both key to managing the risks of returning to business. Getting feedback from employees is also helpful to allow review of the risks and control measures as things progress, and they are going to change as we go along. The general principles of risk assessment are relevant here. 1, identify the hazards which are created by the operation, and here you're going to need to specifically consider those to mental health and how that will be impacted by the current situation and the work environment, and those considerations may well influence the design of the systems of work. Then it's necessary to assess, and that includes the likelihood of the risk causing harm and the magnitude of any harm which would be caused. And the extent of a risk is a combination of these two factors. Even a risk which has potential to cause great harm is not a significant risk if it will almost certainly never come to pass. And in this context, the likelihood of the risk occurring will differ depending on an individual's characteristics And this is something which should be taken into account in the risk assessment process. What's safe for one person may well not be safe for another. And then you need to look at the measures which could be used to control the risk. And this is a balancing exercise. The extent of the risk, on one hand, against the cost of stopping the activity or implementing a control measure on the other. And sometimes a control measure will introduce greater risk than it removes. And in that case, it's not reasonable to implement the control measure. In this context, we've heard about the introduction of perspex screens to control transmission where physical distancing isn't possible. For example, in the cabs of vehicles, but in that instance, the installation of such screens creates an additional risk if there's a road traffic accident, and that becomes unacceptable. So it's a difficult situation, a difficult process there to weigh up the two sides of that equation. But once you're satisfied the risks have been reduced to the lowest level reasonably practicable, then it's necessary to implement the control measures or systems of work, to train and educate the employees, make sure they understand what it is they're being asked to do, and in this context, why it is they're being asked to do it. And then it's necessary to monitor compliance with these, and if necessary, to enforce the control measures. And in this situation, I think that supervision is going to need to be more robust than might ordinarily be the case, and it might be necessary to be more overt about enforcement that's taken to make sure these things are followed. And it's going to be important to support employees, to listen to their concerns and to give them help with things which are difficult. It's all going to be novel at the beginning. And review. And that's going to be particularly key here where things are changing regularly, but also because the situation is unknown and we need to navigate it as we go. And as I mentioned, keeping open communication with employees is going to be a key tool for businesses in that process. But as Carly said, the duty here is not to entirely remove any risk by the process or to reduce it to zero, and it's important to bear that in mind. But what does reasonably practicable mean in this context? There's no change to the duty on employers. The HSE continues to operate on the same basis and has said it will hold employers to the same standards. And this means that the test continues to be that the cost of implementing the control measure would be grossly disproportionate to the risk to render the control measure not reasonably practicable. The government guidance for businesses which have operated during lockdown has emphasised that some necessary control measures will impact, and potentially significantly, on productivity and profitability, and that some operations might not be able to operate safely at all. And so there is no relaxing of existing requirements, no tolerance for things being done less safely than they were in the past, and no defence to a breach of the health and safety regulations that COVID-19 made it more difficult or more expensive to comply. And what does that mean in relation to the COVID-19 specific risks? Does an inability to comply with, for example, the 2-metre rule mean that work can't be carried out? Well, the first challenge here really is working out what the guidance is and where to find it. The HSE has guidance which gives businesses things to think about and some practical suggestions about how to manage the risk of transmission in the workplace. But importantly here, the guidance recognises that it may not always be possible to meet all of the requirements, and that is echoed across the other sets of guidance. The Scottish Government is working at the moment on sector-specific guidance to be released as different sectors are allowed to reopen, and there is currently some guidance for construction, food, household waste and recycling centres, manufacturing, retail, transport and forestry and environmental management activities. There are some key common themes which arise from the different pieces of these guidance documents, and those are also mirrored across the sector-specific guidance issued in England and Wales. So what are those? Well, the common themes are the need for social distancing, keeping a physical distance between workers, the use of barriers where that's not possible, organising work patterns so people are coming into contact with others as less often as is possible, hygiene, hand washing, making sure people clean their hands when they come in and leave work areas, and that there's facilities, soap and water where at all possible for them to wash their hands when they're working. And also that cleaning regimes are beefed up so that areas are cleaned more often and more thoroughly than they were in the past. There's an overall drive to reduce the number of people who are at work out of the home. So reducing the number of workers that are on site and also the number of visitors to the lowest level possible. And that might require some quite sort of important changes to the way that the business is organised, and it's not going to be something that is taken lightly. And communication is key. Keeping your workers up to date, letting them know why you're doing things, how the workplace is going to look when they come back, and what changes they might anticipate in the future. But going back to the 2-metre rule, it's recognised it might not always be possible to maintain that gap between workers. But where closer contact really can't be avoided, and as I've said, the government expects businesses to take quite significant changes to their business to let this happen. Any contact should be mitigated by only allowing it to occur for as short a period as possible. Considering the position of workers, can they be back to back or side by side rather than face to face? Physical barriers be installed between them, so back to the idea of perspex screens. But reducing the interaction between the workers on site to the lowest level possible. And that means not congregating in staff canteens at break times, no gatherings at the beginning and ends of shifts, and then maintaining rigid work team bubbles so that the number of people a worker will be in contact with is maintained as low a level as possible. And as noted, even if these measures cause significant organisational problems and are costly, it will not be acceptable not to put them in place. And it won't be acceptable to reach the conclusion that the 2-metre rule can't be achieved and give up there. If it can't be achieved and there has to be some contact that's closer than that, you're going to have to take quite significant steps to reduce the risks elsewhere. And the last thing I want to touch on was PPE. That's something else which has been much discussed in recent months. And employers will rightly be wondering now, is this something they should be rolling out to all, some or most of their employees? Well, the Scottish Government guidance says that COVID-19 specific PPE is not generally appropriate for workplaces other than high-risk situations such as healthcare settings. And that's because people shouldn't be at work if they're infected. Now, it might be that PPE is appropriate for first aiders or others who will manage those who become ill at work. But it should be remembered that generally, PPE is a control measure of last resort. It should only be used where there are no other means of controlling the risk. It's always far preferable to organise workers so that they don't need PPE, and here, so that they're physically and perhaps also in time distanced from one another. PPE is not a magic wand to avoid having to make more difficult changes to the workplace. In addition, we have to bear in mind the additional risks which are introduced by using PPE and the staff education, monitoring and enforcement which would be required to keep it safe. So, in summary, there is no loosening of the existing health and safety obligations. Those must continue to be met, notwithstanding the difficulties introduced by the pandemic. And all steps, aside where those are grossly disproportionate to the risk, must be taken to reduce the risk posed by COVID-19. Absolute compliance is not required, but there is a heavy duty on employers to do all that they can to reduce the risk of transmission, and this may require whole-scale reorganisation of the workplace and the operations. A key component of any return to work strategy will be communication with staff, which goes in both directions, and a keen oversight of what's actually happening in practice. Ultimately, we are all taking a step into the unknown, but the underlying principles of health and safety are good guides in these uncertain times. Gemma is now going to look at how claims might be defended if they are received, and what steps can be taken now to offer the best arguments in the future.
Thanks, Kate. So I'm now going to have a look at the potential lines of defence which we envisage may be available in response to a direct COVID PI claim. Now, by direct PI claim, I mean one where the claimed injury is one of infection. The thought process applied to whether or not a direct claim can be defended has the same starting point as for any other PI claim. That is, can the pursuer prove his or her case? This is a relevant question because, of course, the burden of proof rests on the injured person to convince a judge, or in some cases jury, the person being sued is responsible for causing the injury sustained, or in this context, contracted. The vast majority of direct COVID PI claims will be founded in negligence. That is because most will arise from exposure in the workplace, And as you will know, to succeed in a claim for negligence, the pursuer must persuade the court of three things. First, that the defender owed them a duty of care. Second, that the defender breached that duty. Third, that the breach of duty has caused them to suffer loss. Overcoming the first hurdle and establishing that there was a duty of care will be a formality for workplace claims made by employees. It is, of course, well established that an employer owes a duty of care to such persons. That same employer will also owe a duty of care to visitors and non-employees who use their premises. For off-site claims against that employer, that is, where exposure occurs on third-party premises, for example, a building site, to persons working other than under a contract of service, arguments surrounding the duty of care may arise. The infected person could well argue that he or she should be viewed as akin to an employee. In that scenario, the well-known issues of integration and control must be considered in the context of the pursuer's role as a matter of fact. So, if for today's purposes, we concentrate on the duty of care owed by an employer to its employees, well, that duty, stated in general terms, is to take reasonable care to protect employees from known or foreseeable risk of injury. So the first question to be addressed, and which may provide scope for defence argument, is when did the risk of injury from COVID-19 become known or foreseeable? Well, there's no clear answer to that question yet, and ultimately it will be for the courts to decide. But our sense at this stage, in the context of mainstream business, that is excluding health or social care providers, is that the earliest date which may be argued for is 3rd March 2020. On this date, the UK unveiled its Coronavirus Action Plan, and Public Health England confirmed that widespread transmission of COVID-19 within the UK was highly likely. But more probably, the likely date is 16 March 2020, when the Prime Minister advised against non-essential travel and contact with others. The latest potential date, as we see it, is 23rd March 2020, when lockdown began. So once the risk of contracting COVID became known or foreseeable, the pursuer's case will be that a duty to act arose on the part of the employer. So if we pause at that point, from a defence perspective, it might be possible to resist the suggestion that the duty to act did arise immediately. Disease and noise-induced hearing loss cases tell us that an implementation period is normally granted before an employer will be viewed as in breach of their obligations, and it is very possible the same approach will be taken to COVID cases. The period, if any, is likely to be short, but defence arguments of this type may be statable where the alleged date of infection occurred in the immediate vicinity of 16 March, particularly for smaller scale but essential businesses. And gathering documents to confirm or approximate the date of infection could therefore be very important. Those documents would include medical and absence records, testing records, be that for temperature or directly for COVID, and potentially witness statements from the pursuer's family members. But if we assume for now that the pursuer does establish there was a duty to act, the next defence consideration is what act or omission does the pursuer say was negligent? The allegations we expect to see are firstly those focused on risk assessment. That is, the failure to prepare one, or if one was prepared, the failure to make it suitable and sufficient. In the latter instance, suitability arguments are likely to focus on whether high-risk groups were properly considered and whether, in general, adequate control measures were identified to prevent the risk of spread. Another potential fault strand is that the control measures, although identified and adequate, were not implemented properly or at all. So against that background, if an employer is to defend a COVID claim, the first vital step is, of course, that they can produce the risk assessment, or more hopefully, a series of risk assessments prepared in response to the risk of infection. The assessment is the foundation upon which any lawyer will look to build the claim defence. Its importance cannot be overstated. And whilst it seems obvious, businesses must remember not just to produce those documents now at the point of the health crisis, but to safely store them so that they can be easily referenced and produced at the point when a claim is made. Reviews or updates to the assessment should be made obvious and overwrite avoided. Drafting each assessment as a separate document is preferable. Doing so will also allow defence lawyers to build a much clearer picture of the business's timeline of compliance efforts. Stating who in the organisation completed each assessment is also very important. Businesses must prepare for the content of the assessments to be questioned. The drafters will be the key rebuttal witnesses on this point and need to be easily identifiable. It must be remembered that some COVID claims may not enter court until 2024 or even later. And by that point, memories of who did what may have faded. So I mentioned there being able to evidence the business's timeline of compliance efforts. Why is that important? Well, because the content of government and HSE guidance will play a key role in informing the court's view on what a reasonable employer ought to have done. The guidance itself, as Kate has mentioned, has been fluid rather than static. It is therefore entirely possible that what was legally acceptable and compliant one day may not have been the next. With that in mind, to increase defence prospects, employers need to be able to evidence what they were doing and when. For example, new guidance was issued to NHS trusts on 28 May 2020 on how to assess the risk posed by COVID to Black, Asian and minority ethnic staff. That such persons were high risk was not publicised at the beginning of the outbreak. Another way in which defence prospects can be increased is where a business can evidence the thought process behind completion of the risk assessment, and in particular, the decisions made on what control measures to adopt. As Kate has said, an employer's duty is not one of insurance. It is only to ensure, so far as is reasonably practicable, that the safety of employees is protected. It is expected the court will pay very close attention to arguments relating to what was reasonably practicable when deciding on any COVID case. When doing so, the court will not look at what was physically possible. The assessment has always been and will continue to be much narrower than that. As Kate has already touched upon, it is effectively one of balance. The likelihood and potential severity of risk is placed on one side of the scales. The sacrifice involved in adopting measures necessary to avert that risk, whether in money, time or trouble, is placed in the other. If there is a gross disproportion between them, the risk being insignificant to the sacrifice, the defender will avoid a breach of duty finding. Notably, the PPE regulations explicitly tell an employer that they must take into account any risks which may be created by the provision of protective equipment. Employers should not only perform this balancing exercise at the outset, but be able to evidence that fact and its content. By so doing, they will be better placed to defend a breach of duty claim. Factors such as a greater or competing risk of injury, restrictions of space, lack of financial means, an inability to safely modify existing equipment, vehicles or premises, and/or difficult supply conditions may all have played their part in the decision made not to adopt or implement a particular control measure. By way of example, in Madrid versus the Police Service of Scotland, one of the issues for the court to determine was whether a police officer engaged in a restraint exercise should have been provided with goggles. The court held no. It did so because the risk of injury through being thrown to the floor whilst wearing goggles was greater than the risk of injury to the eye from not having them at all. Accordingly, the provision of goggles was not an effective way to prevent injury without increasing the overall risk. Being able to evidence the balancing exercise will be of vital importance where an employer has not followed government guidance on, for example, social distancing. So what documents will be important? Well, businesses should think about retaining, for example, any relevant health and safety minutes, site surveys, assessments or recommendations made by external advisors, employee engagement responses, purchasing requests or stock inquiries, and relevant financial account data. It's probably worth pausing here to say that lawyers will be paying very close attention to what the courts say and do when they start to consider COVID cases. Really only when that process starts will we be able to critically and comfortably review the strengths and weaknesses of the individual balancing exercises performed. But whilst we wait for that precedent, it's worth remembering that businesses who can evidence a careful, collaborative and transparent health and safety culture will always fare better at proof, both in regards to the assessment of liability and also with regards to reputational costs. Moving back now to key defence considerations, well, comparator evidence is also likely to play a key role in the success or otherwise of COVID claims. Industry standards will, like government and HSE guidance, inform the standard of care. If a business can show that there was an industry standard and/or that their competitors were doing the same, then a defence argument that the business acted adequately and lawfully will be made easier. Retaining what the industry-specific guidance says is prudent, and so too keeping hold of any communications the business has had with trade body representatives or their trading counterparts. So being able to evidence completion and review of the risk assessment and the rationale for its content will be very important. But the risk assessment document is only the blueprint for action. Businesses must, in addition, be able to show that they did, in fact, put that blueprint into action. They must be able to evidence that the control measures identified were implemented and, where necessary, enforced. How is that achieved? Well, it's the same process as for typical EL claims. It will be by reference to documents such as PPE distribution records, PPE use compliance records, training records, safe system of work documents, photographic evidence, disciplinary documents, and workplace policy documents. It is important to remember, of course, the key role which technology can play. This is particularly true for businesses with home working or furloughed employees who are now waiting to return. Those businesses should consider whether training can be completed online, for example over a channel like this, and whether safety documents can be accepted and reviewed on screen. Online surveys can also be used to evidence employee input into the risk assessment process and potentially any return to work framework. So I've mentioned safety documents quite a bit there in the context of breach of duty arguments, and that's probably not surprising to any of you, but it is, I think, fair to say that safety documentation is of more importance in a COVID claim than in a typical EL claim. Why? Well, for COVID claims, there's unlikely to be any immediate post-incident golden hour to collect rebuttal evidence, such as witness statements, photographs, or the pursuer's account. This reflects that, as the World Health Organization tells us, it can take up to 14 days for a person to show symptoms of COVID after infection. So with no opportunity for an immediate post-incident investigation, a defender's armoury will be lighter in the context of a direct COVID claim than in a more normal EL case. That all said, I'll now pass you back to Carly, who will look at the more technical defence arguments which we expect are likely to be available.
Thanks, Gemma. So as Gemma said, I'm going to talk to you about causation, because we do see that as being a key in the defender's armoury for defending these claims. We anticipate causation being the main hurdle for pursuers to overcome, and particularly in relation to infection claims. Now, breach of duty is one thing, but proving that that breach is what actually caused the pursuer to contract COVID is a more difficult hurdle for pursuers to overcome. That's particularly true for pursuers who don't live alone, or for those who work in more than one place. They've perhaps been volunteering, perhaps used public transport to get to work. And that's all the case because of the prevalence of COVID within the community. We all know the ease of transmissibility of the virus, and also the lack of tracing data currently within the UK. It's thought that proving causation may be easier for pursuers who were infected post-lockdown. By that point, of course, potential sources of infection were more limited, and the only reason for going out may have been to go to work, but equally, people also left their house to exercise and to go to the shops. Now, from a defence perspective, exploring when the illness was contracted is again very important. Being able to show that it was pre-lockdown or as social restrictions began to ease could be a means of introducing significant risk into the pursuer's claim. The rate of infection amongst the workforce will also be a key indicator of the strength of the defence position. So if you consider instances of so-called cluster claims, so numerous claims against one employer, that may mean that the pursuer's prospects of success could increase, bearing in mind the test is on the balance of probabilities. So several employees, all of whom work closely together, have contracted the virus, then that could be enough to succeed, but it's not without doubt. I should say that the difficulties I've mentioned with proving causation arise from the assumption that causation is addressed with reference to the but-for test. So that test requires a pursuer to show that he or she would not have contracted the virus if the breach of duty had not occurred. So we could envisage a situation where a pursuer might argue that a material contribution approach should be adopted by the court. That means a pursuer wouldn't have to isolate the exact cause of the injury. They would only have to show that the defender's breach had made a difference to the outcome. But realistically, will the court take that step in a COVID claim? Well, our feeling that is probably not. Current science tells us that COVID-19 arises from a single moment of exposure. So in contrast, the material contribution approach has been endorsed in cases of divisible injury. So that is where the occurrence, severity or progression of a disease or an injury is related to an amount of exposure over a period of time. So COVID is not really aligned to the factual context in which a material contribution approach to causation has been seen before. And persuading the court to adopt a material increase in risk approach could also be difficult. I mentioned a couple of cases on the slide, but the claimant in the Fairchild case could not establish the precise cause of her condition. Now, in that case, the court held it was enough that the breach by her previous employer created a material increase in the risk of her contracting the disease. But the Supreme Court made clear in the Grief case, which I've referred to, that it was very wary of adopting this approach in non-meso cases. And the defence stance will be in the Fairchild approach should remain limited to those cases. The Supreme Court did suggest that where the breach increased the risk of infection by more than 50%, Fairchild could still have legs, but whether such arguments can be substantiated with reference to expert evidence is still far from clear. So causation could prove difficult for pursuers, and in addition, businesses may be able to rely on arguments of sole fault and contributory negligence to defeat or restrict claims that are made. And the lines of argument we foresee will become commonplace in COVID claims are those which relate to, for example, entry into restricted areas, failure to wear or to use PPE which has been provided, or to wear or to use it properly. Use of unauthorised PPE, so if an employee decides to use their own mask or their own gloves and they haven't been subject to the necessary quality control process. Failure to comply with revised work procedures or agreed cleaning regimes, and a failure by an employee to look where he or she is placing their hands or feet, for example. A failure to follow social distancing markers or one-way systems that have been put in place. Now, of course, as is the case for typical EL claims, those lines of argument will only be viable if the business can point to and evidence that the employee ought to have known better. I think achieving that, as Kate and Gemma have said, will be made easier when training records can be produced, the employee review of any COVID risk assessments and revised work procedures can be evidenced, PPE distribution is documented, instructions given are able to be confirmed in writing. As I said at the outset, there is no precedent here, and there are no reported decisions involving contrib in a COVID context. But just by way of example, in the case of Spencer against Bartholomew, this case involved a school pupil who didn't wear a gum shield issued for playing rugby. And the school could evidence that the claimant knew to wear this item of safety equipment and that its use was frequently reinforced by staff. So the claimant in that case didn't succeed in liability, but the court said that had he been successful, damages would have been reduced by 75% in respect of his failure to obey a known safety practice. And the key points to take from that case are that the defender could evidence the pursuer knew to wear the equipment and its use was frequently reinforced. I do think it's worth saying, we all know it can be difficult in an EL context to obtain such high deductions for contrib, but I do wonder what the approach by the courts will be in relation to COVID cases. We know the court, when looking at contrib, will look at causal potency and blameworthiness. And if we take a scenario whereby an employee fails to adhere to his or her employer's instructions, for example, to follow a one-way system that's been introduced to minimise the risk of employees coming into contact with each other, the argument we're often presented with is, well, it was a momentary lapse of concentration or inadvertence. Is that really a sustainable argument given the media reporting and the widespread guidance across the globe about the importance of social distancing and minimising the risk of infection given the transmissibility of this disease? It's an immensely difficult position for so many of us, and as I say, it remains to be seen how critical the courts will be of employers and employees and the standards which will be applied, both when looking at whether an employer has breached their duty and or whether an employee has contributed, and if so, to what extent. I think it has to be recognised that there are so many organisations working in difficult and challenging environments with a lack of definitive guidance on what they ought to be doing. And I suspect the court will have to take that into account when assessing these claims. Finally, I just wanted to touch upon quantum. Normally in the assessment of a live claim, the next step would of course be to look at quantum. Now, we don't have time today to discuss all the issues that would arise in that regard, but it is something we'll be providing our views on in the coming week as part of the claims campaign. And of course, we'll continue to share with you our reflections on the lines of defence argument we've touched upon today and those which arise as we move forward. So thank you to everyone who has been listening, and I think we have a little bit of time to be able to take some questions. And if we run out of time, we will respond to you directly. One of the questions actually which is up my street was what happens when someone dies who had underlying health issues. And it's obviously been widely reported that those who die from COVID are likely to have underlying health conditions. So also age is going to be a factor. So therefore life expectancy arguments would be a key issue. Cause of death will also need to be established. So was it COVID or was it an underlying condition or both? And it's likely to need expert medical evidence on that point. And I've just got a question here that I think is probably best for Kate. Kate, we've got a question about what about a scenario where there are people in vulnerable groups who want to come back to work and they're happy to take the risk?
So I think that's quite a good question. So as I mentioned in relation to risk assessment, one of the things about this disease is the risks differ from person to person. So if you've identified that there are people with certain characteristics that are at greater risk, and the suitable control measure for that is to ask them to work from home or to furlough those workers or to ask them to work in a slightly different way, then if they say to you, I don't want to do that and I want to continue to work in my normal role, the employer can't allow them to continue working because the employer's identified that as a risk and a risk against which there is an achievable control measure. So it's different to a situation where an employee doesn't do what they're told and the employer has no way of knowing that that's happening. An employer can't condone someone overriding or overruling a control measure. I think in practice that could be quite a sensitive area for employers and it might be difficult, but in terms of health and safety duties, the employer's duty is to not allow that person into the workplace and to not allow them to be at risk.
There's another question about CPAP. Gemma, do you anticipate CPAP applying to COVID?
I think my view on that one is probably not. The wording of the protocol explicitly confirms that it won't apply to injuries which take the form of a disease. And the term disease includes as far as I remember, any physical illness. But it's probably worth remembering that it's still open to parties to volunteer to agree CPAP. I think that will be an important consideration to the extent that any COVID claim is received by an insurer or business.
I think we've got another question about anticipating claims for secondary exposure. I think that's a good question. I think that's subject, the answer would be yes, but subject to the same test in terms of causation. And also, I think just a final question, if we can squeeze this one in, do we think the UK will take a similar stance to that being considered in the US to compel insurers to pay out on policies in terms of BI cover? I suppose we'll have to wait and see what the FCA High Court opinion is on that issue. It will be telling, obviously in the UK there is the business interruption loan scheme, which obviously is not the same as an insurance payout. But I know that many insurers have taken a view on policy wording that maybe was in dispute. They've taken differing views on similar wording. So I think the FCA will direct some consistency in terms of how it's approached. I don't know, we might still see Trump weighed in because he has jurisdiction and everything, who knows. Okay, well, I think we're at time. So there are some more questions which we will reply to directly. But I'd just like to say thank you to everyone for joining us today. And as I said earlier, there is so much to discuss, and this is a constantly evolving pandemic. We are all in it together in terms of trying to navigate our way through in the short, the medium and the long term. So if there are any specific issues, then please get in touch to discuss them, or you want us to provide comment, then please just let us know. So thanks again for joining in and hope to see you soon.